While questioning an obstetrician in a medical malpractice case during a deposition, the doctor refused and did not want to answer my question about what was the standard of care. Would you like to know what I did in response to her telling me she didn't know what the standard of care was? Come join me in this walk through the neighborhood as I share with you exactly what happened. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, this was an obstetrical malpractice case. And now, during the course of my questioning of this doctor, I had a chance to ask the doctor questions not only about what she did and why, but importantly, I wanted to establish what was the standard of care. Now, why can I do that? Number one, I'll tell you why. Because in New York, I am permitted to question the doctor whom you have sued as if they are a medical expert. Now, we may question whether or not they truly are a medical expert, but the law looks at them as being a medical expert. Why is that? It's because they have additional training that most lay people don't have. They went to medical school. They did a residency in obstetrics and gynecology. They may have gone on to a fellowship for additional training. And then they were in practice for a number of years. And presumably they've treated these types of conditions and cases before. Okay, so that means that in New York, I am permitted during a deposition to ask this doctor questions about their expertise, questions about their knowledge of the medicine. I am permitted to also ask them questions, what's known as hypothetical questions. Now, what's that? A hypothetical question asks the doctor to assume that our version of the facts are true. Now, why do we do that, and why do I get to do that? I get to do that because during a medical malpractice lawsuit, there are different versions of the facts. There are disputed facts. We argue that my client went into the doctor's office and made complaints of A, B, and C. The doctor disagrees. The doctor said, the patient never told me about A, B, and C. Instead, she told me about X, Y, and Z. So there is a different version of events. And in this hypothetical scenario, I'm arguing that if the doctor learned that the patient complained about A, B, and C, then she would have done the following steps. But in this case, she didn't do the following steps. So a hypothetical question allows me the opportunity to present our version of the facts as if they are true, and then to get the doctor to answer those questions about what she would have done and what the standard of care was if this patient had in fact come in complaining of those particular things. So now in this particular deposition, which by the way lawyers also call an examination before trial, it's really a question and answer session that's given under oath. And during COVID times, it takes place on a Zoom video call. The answers that the doctor gives represents her sworn testimony, and it carries the same exact weight as if she is testifying at trial, in court, in front of a judge and in front of a jury. So how does this get recorded? Do we simply press the record button and that's it? No, there is a court stenographer on the call. The doctor's lawyer is on the call, the doctor's on the call, I am on the call, and the court stenographer is there to record all of the questions that I ask and all of the answers that the doctor gives. Okay, so in this particular case, going back to the title of this video, I needed to ask the doctor what was the standard of care for this particular condition. And instead of giving me a straight answer about what was the standard of care, and by the way, the doctor, an expert in her field of medicine, in obstetrics and gynecology, is expected to know what the standard of care was. They're treating the patient. They should know what is good practice. They should be able to recite what is appropriate care for a particular scenario. I asked the doctor, if a patient comes into your office for a prenatal visit with the following complaints, would you agree that good medical practice requires that you assess the fetal well-being, the baby's well-being? Yes, I would. In that instance, how do you go ahead and assess the baby's well-being? Oh, we do a couple of tests. One is known as a biophysical profile, which is an advanced ultrasound test to determine whether or not the baby's okay. And another test is called an NST, a non-stress test. That also evaluates the condition of the baby. So when I asked what the standard of care was in this particular scenario, the doctor's answer was, I don't really know what the standard of care was for this scenario. However, I'll tell you what I do in this instance. And the doctor proceeds to tell me exactly what she would do, which includes getting a biophysical profile and obtaining a non-stress test. And I said, doctor, I didn't ask you what you do. I asked you what the standard of care was. And again, she reiterated and said, listen, I don't really know what the standard of care is. There's no published guidelines about what the standard of care is in this scenario, but I'm telling you what I do. And I said, okay, doctor, the reason you order a biophysical profile is because you want to assess the condition of the baby in that instance, correct? Yes. And you would recognize that that represents good medical practice. Isn't that true? Yes. And that would be true regardless of whether it's a physician in your particular town or a physician anywhere in the United States. Isn't that true? Yes. Isn't that what the standard of care really is, doctor? And the doctor had to admit and acknowledge that yes, that was the standard of care, which is exactly what I was trying to obtain. All she had to do instead was simply tell me what the standard of care required in this particular instance. But you know why she didn't want to do it? She didn't want to lock herself in to the fact that she admitted and acknowledged that this is what needs to happen when a patient comes in making the following complaints. Now, why is that? I'll tell you why. Because she's been through the lawsuit process before. She knows that the moment she goes ahead and acknowledges that something is the standard of care, she has now locked herself into a box. And why is that important? Because later on during the case, I'm going to go through every single note about every treatment that she rendered to this patient. And if it turns out that the treatment that she rendered deviates or departs from what the standard of care was, that establishes liability. So it allows me the opportunity to prove, using the doctor's own words and what she considers to be the standard of care, exactly what should and should not be done. Now I have to share something else with you that nobody really talks about. Despite the fact that I'm trying to get the doctor to talk about the standard of care, rarely will the doctor ever admit and acknowledge that they violated the standards of care. Because if they do, half the case is over, or I should say a third of the case is over. Why? Because in these medical malpractice cases, I have to show not only that there was wrongdoing, that the doctor departed from the standard of care, I have to show that that wrongdoing was a cause of your injury, the patient's injury. And I have to show that the injuries are significant or permanent. All three of those things have to be present in order to have a valid case. So if I can get the doctor to go ahead and acknowledge and admit that yes, these are the standards of care, and yes, my treatment did in fact depart or deviate from the standard of care, well, guess what? Now I've established liability. And the next question obviously is, okay, doctor, would you agree that failing to do those things would result in the following injury? Objection! Go ahead and answer, doctor, which is what the defense attorney will have to say. And then the doctor is going to have to answer that question. We call it a causation question, to tell me whether or not failing to do certain things caused my client those injuries that she's now complaining of. So why do I share this great information with you? I share it with you not to show you the beautiful scenery here with the cars driving by, but I share it with you to open your eyes and help you understand how these types of cases work. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.